and sharing best practices. We're really delighted to have you with us today. I'd like to start by extending my appreciation and warm thanks to our panelists for their participation. Mr. Kazuho Taguchi, Minister Counselor from the Permanent Mission of Japan via video message. Mr. Olivier de Frouville, member of the Committee on Enforced Disappearances, and for his continuous support to initiatives to promote the ratification of the Convention in the region. And Ms. Anka Nanilapajit, member of the Working Group on Enforced or Involuntary Disappearances, who's been at the forefront of efforts to end this criminal act and to encourage ratification in the region. I would also like to thank Ms. Grace Fernandez and Mr. Juan Carlos Gutierrez from Mexico for accepting to share with us via video message their experiences. This convention is the result of tireless dedication, hard work, and advocacy that was done by countless families of disappeared persons, human rights defenders and experts, NGOs, and member states from across the world. Ratification rates in Asia, unfortunately, remain quite low. Currently, only 4 countries have ratified the convention, including Cambodia, Japan, Mongolia, and Sri Lanka, and 4 more have signed but not yet ratified, including India, Indonesia, the Maldives, and Thailand. Enforced disappearances are regrettably continuing to take place across the globe, but also in our region. In Asia, 18,350 cases of disappearances have been reported to the working group between 1980 and 2021, of which 10,258 remain unresolved. In addition, we are aware of cases of enforced disappearances that never get reported to the working group, as families are too often afraid to report. Why has the establishment of this legal framework been so critical? Well, you will hear more about this from our panelists later in the webinar, but I wanted to touch on a few key points. Since its adoption in December 2006, the Convention has filled an important judicial void in the international system by providing a binding legal instrument to fight enforced disappearances. It qualifies the widespread or systematized practice of enforced disappearances as crimes against humanity. It prohibits secret detention locations and reinforces procedural guarantees surrounding detention. It provides families and relatives with a right to know the truth about a victim's fate, ensures that no extenuating circumstances can ever be invoked to justify an enforced disappearance, and it concerns prevention as it covers the implementation of mechanisms of surveillance and early warning. The objective of today's webinar is to highlight the relevance of the Convention for our region, to strengthen knowledge of its provisions, and to have an opportunity to interact with international experts, both from the Committee on Enforced Disappearances as well as the working group. It also affords us the opportunity to learn from the experience of civil society organizations and human rights defenders in other parts of the world on their work to promote the Convention. To support this effort, OHCHR has recently published a training guide to facilitate a greater understanding of the rights and corresponding obligations that are enshrined in the Convention. The training guide draws on the committee's expertise and experience, including its concluding observations on states parties' reports, its jurisprudence of individual communications, and its urgent actions. It is a practical tool that we hope will assist states and other stakeholders both in promoting ratification, but also in strengthening implementation of the obligations in the Convention for states parties. Thank you again to the speakers and to all of the participants for being with us today, and I wish you an excellent webinar.
Thank you very much, Cynthia. I will now give the floor to the video message by Mr. Kazuho Taguchi, Mr. Counselor of the Permanent Mission of Japan. Nok, if you would like to start the video. Thank you very much.
Thank you. Japan welcomes the recent publication of the training guide of reporting under the International Convention for the Protection of All Persons from Enforced Disappearance. We are proud that we were able to financially support issuing this important document and wish that all states maximize the use of it. We appreciate the headquarters of OHCHR in Geneva and its regional office for the tremendous efforts they put in to draft the training guide. It is now 12 years since the convention entered into force in 2010, and yet enforced disappearances continue to occur all around the world. At the same time, the fate and whereabouts of so many who disappeared in the past remain unknown. Enforced disappearances deprive the future of the victims and tear the families apart. It is a serious human rights violation and a matter of grave and universal concern of the international community. The abduction of foreign nationals, including Japanese nationals, by the DPRK is a serious and grave human rights issue. It is an issue that must be urgently resolved. It has been decades since they were abducted. The abductees and their families are aging, and we cannot afford to wait any longer. We highly appreciate your understanding and cooperation of the international community to achieve a swift resolution of this issue. Japan will continue to play an active role in resolving all enforced disappearances, including the abduction issue, in cooperation with the international community. As prescribed in the convention, no one shall be subjected to enforced disappearance. Japan pays tribute to the committee for its efforts to monitor its state's implementation of the convention and ensure protection of all persons from enforced disappearance. Japan has been calling upon states that have not yet ratified the convention to do so in various occasions, including in the Universal Periodic Review. We have also been a member of the core group of the resolution on enforced disappearance and hope that states, especially those in the Asian Pacific region, will seriously consider ratifying the convention. The training guide, designed to facilitate the understanding of the rights enshrined in the convention and the corresponding obligation of state parties, will definitely help states to build a deeper understanding of the content of the convention. It will also assist the states to fulfill its obligation to ensure respect for human rights and to engage with the committee actively and constructively. We again commend all the efforts that were put into creating the training guide and hope all states will maximize the use of it. Thank you.
Thank you very much. Thank you very much for this video. We will now start with the substance of this webinar, and I have the pleasure to give the floor to Mr. Olivier de Frouville, member of the Committee on Enforced Disappearance, who will tell us more about the convention itself and the training guide, the training manual. Thank you very much.
Thank you so much for your invitation to participate in this webinar. I'm very happy to be here, also representing the Committee on Enforced Disappearances, which is the body in charge of supervising the application of the convention. I've been asked by the organizers of this webinar to do 3 things today. In 15 minutes, I'll try my best. The first thing is to present a short historical background. And if you could just put the next slide, please. And the second thing would be to just do a short overview of the key provisions of the International Convention. I would just outline the structure of the convention, and I would be ready, of course, to respond to any questions that you may have on particular provisions, and then to underline the convention's relevance to Asia. And I would do so with the help of the working group on enforced disappearances, knowing, however, that we have a member of the working group that will speak just after me and that will explain more the work of the working group in this context. So just start with the next slide, please, with the definition of enforced disappearances, which is given by the convention. There has been several definitions along the history of international law applicable to enforced disappearances, but this is the definition that you can find in the UN Convention, and it reflects international customary law. Article 2 states that for the purpose of the convention, enforced disappearance is considered to be the arrest, detention, abduction, or any other forms of deprivation of liberty by agents of the state or by persons or groups of persons acting with the authorization, support, or acquiescence of the state, followed by the refusal to acknowledge the deprivation of liberty or by the concealment of the fate or whereabouts of the disappeared person, which place such a person outside the protection of the law. So we usually say that there are 4 elements to enforced disappearances: the deprivation of liberty, a state agency element, and then the refusal or the concealment of the fate of the person, and lastly, fourthly, the placement of the person outside the protection of the law. Another element that has to be added in the connection of or in relation to the issue of the definition of enforced disappearances is Article 3 of the Convention, which also draws the attention on acts such as enforced disappearances that are committed by persons that do not act under the control with the acquiescence of the authorization of the state. And more we can see that non-state actors like armed groups, for instance, also perpetrating enforced disappearances, sometimes amounting to crimes against humanity. Now, if we come back in history, and if we try to trace back this practice of enforced disappearances, it's probable that you could find examples throughout whole history, of humanity. And we can also recall some practices during civil wars or armed conflict. You can think, for example, of Spain, the civil war in Spain, 1936. But generally, the historians draw attention on what has been the first somehow written codification of the practice. If you could put the next slide, please. And this codification of the practice was done. I have an echo here. I don't know how. Oh, maybe somebody has his mic on.
Yes, I'm putting the people on mute.
Okay, thanks. So the first codification of the practice was done, the first and only codification. It's the first time that you can see it written down in a decree, in fact, was adopted by Hitler in 1941, and it's called the Nacht und Nebel, the Night and Fog Decree. And here you can see really the practice put down on paper. The Nuremberg Tribunal states in one part of this judgment the following sentence: on 7 December 1941, Hitler issued the directive since known as the Nacht und Nebel Erlass, under which persons who committed offenses against the Reich and the German forces in the occupied territories, except where the death sentence was certain, were to be taken secretly to Germany and handed over to the SIPO and SD for trial or punishment in Germany. And if you could put the next slide, this is an extract of the Justice case, which was a judgment adopted after the war by the American tribunal in Nuremberg. And it's really striking because it really echoes what we know of enforced disappearance as a contemporary practice. And I quote, during the war, in addition to deporting millions of inhabitants of occupied territories for slave labor and other purposes, Hitler's Night and Folk program was instituted for the deportation to Germany of many thousands of inhabitants of occupied territories for the purpose of making them disappear without trace, and so that their subsequent fate remain secret. This practice created an atmosphere of constant fear and anxiety among their relatives, friends, and the population of the occupied territories. So here you really have somehow the essence of the practice that unfortunately spread throughout the world after World War II. If you could put the next slide, please. The moment where the practice was really put into light somehow was in Latin America in the 1970s. And the first practice that really came under the focus was Chile. After the coup d'etat in 1973, there were a number of people at that time that were said to be missing. So, you know, it was the way it was called, the people went missing, but it was clear from the reports by civil society organizations or international organizations that in fact those people didn't go missing just like this. They were arrested by security forces and they were taken into secret detentions, and sometimes they came out, but most of the time they did not come out, and it was impossible to trace their fate. And this is the very moment where the United Nations, but also the regional organizations, started to get interested into this and to identify this phenomenon as a practice of violation, massive violation of human rights. These are the figures that are taken from the Working Group on Enforced Disappearances report that Ankana Nirajaparit will speak about just after me. Just please take note of the fact that the figures that are contained in the report are not the real figures, so to say. They only reflect the figures that have been reported to the Working Group, which means that you only have a slight view of the numbers, the real numbers of enforced disappearances that occurred in the situations. I will present some other tables such as these that you can find in the report of the Working Group. And of course, these figures are just part somehow, or sometimes are only the tip of the iceberg, okay? So Chile was the first situation that really drew attention in this regard. And then Argentina, which is the next slide. And you can also see that the peak here is really from 1975, from the starting of the coup. In most of the situations, you will see that there is a peak, which really shows that the phenomenon of enforced disappearances is in general linked to a situation of crisis, right? So Argentina, 1975, 1981, here you can see huge numbers of enforced disappearances, and the phenomenon really grew massive in Argentina, but also in other countries of Latin America. Subsequently, it was discovered that there was an international coordination of agencies, security agencies of those dictatorships to disappear opponents in their respective countries. This was called the Plan Condor. And this is also one of the reasons why the practice became so massive. From the action of the woman, you can see here on the photograph that is showing the pictures. the practice became to be called enforced disappearances and not missing persons. You know, the civil society and the families really insisted that those people didn't just go missing. They were abducted by state agents and they were taken into secret detentions and they were forcibly disappeared. And that's when the word enforced disappearances started to become in use before international organizations. So as I said, unfortunately, and that's the next slide, subsequently the practice spread out throughout the world and on all continents. So this is really, now we are really facing a universal phenomenon. On all continents, there are enforced disappearances. Enforced disappearances are used in different contexts as a practice of terror, as a massive violation of human rights. These are, again, some of the figures that are taken out of the working group report. Again, a lot of under reporting. There are certainly cases in some countries that are not reported, and all the figures that you can see are really, again, in general, the tip of the iceberg. Okay, but just to show the spread of the phenomenon all over the world. This is just, in other words, this is not a Latin American practice. This is really a practice that spread all around the world. Could you show the next slide? The next slide shows the figures of the working group in its last report. So again, you know, keep in mind that this is only part of the phenomenon, but currently there are, since 1980, almost 60,000 cases have been transmitted to 110 states. In 2021, there are still 46,000 cases more that are pending in 1905 cases, and the working group clarified 376 cases. If we look at the various situations of enforced disappearances, that's the next slide. Mostly you can find three types of situations where enforced disappearances occur: armed conflict or disputed territories, colonial conflicts like France in Algeria, but also interstate countries like in Cyprus, internal conflict like in Lebanon. You know, all these issues, interstate or international conflict, generally, or in some cases, trigger enforced disappearances. Another type of situations are the political crisis or internal troubles, when a government is attacking subversive or terrorist forces in the name of national security. You can think of Indonesia in 1965, Operation Condor in the 1970s, in the Philippines, Marcos, or in Morocco with Hassan II, etc. And the last situation, classical situation, I would say, is when you have a totalitarian, authoritarian regime that is stifling opposition groups, dissidents, separatists. You can think of North Korea or China, for instance. Next slide. You can see that there are some evolving situations, or new situations, you could say. They're certainly not so new, but in a way, they are more and more in focus. And you can see that there are new practices of enforced disappearances that are developing throughout the time. You can think of enforced disappearances in the context of war of terror in the beginning of the 2000s, where the United States and some European states became involved in a practice of extraordinary renditions, which was mostly, a practice of enforced disappearance, abducting people and taking them to other countries. Disappearances by non-state actors, I was mentioning this in the beginning, which is when you have a non-state actors, an armed group, a quasi-state administration, you may have a similar practice to enforce disappearances occurring with people that are abducted, and again, the refusal to provide information. And a difficult situation, a difficult issue is when enforced disappearances is mixed with organized crimes. And it's really sometimes difficult to distinguish between enforced disappearances and more ordinary crimes. So you could say, you can think of smuggling, trafficking, illegal adoptions, femicides, like in Ciudad Juarez in Mexico. And then lastly, something that is really developing and that we are more and more aware of is the enforced disappearances in the context of migrations, which is sometimes linked to organized crimes, but not only. Or you may also have a state agency element. Next slide, please. Now, the international law on enforced disappearances developed quite slowly. You could say from the 1970s till the 2000s. The first approach was from international humanitarian law, right? It's quite logical because the phenomenon of disappearance was first taken into account in the situations of armed conflict, internal armed conflict or international armed conflict. The first optional protocol to the Geneva Conventions takes particular notice of the situation of missing persons. And in the context of international humanitarian law, we're still speaking of missing persons because it includes enforced disappearances, but it's not limited to enforced disappearances. You may have people that are, for instance, soldiers that are missing in action. They are missing persons, but not necessarily disappeared. But in some case, they might be disappeared. If you imagine, for instance, a soldier which is abducted by the enemy force, which is executed and which is, which remains are hidden, this is an enforced disappearance. So you have different practice in the context of armed conflict, but are generally looked at by the RCRC, for instance, through the lens of missing persons, whereas we use the more particular categorization of enforced disappearances, right? In the 1970s, as I said, and thanks to family associations, there was this more precise categorization of enforced disappearances distinguished from missing persons. With this idea that those people are not just missing, they have been abducted forcibly. This is the context of 1970s with Operation Condor. Then subsequently in law, the phenomenon was taken into account by general human rights bodies, like the Human Rights Committee or the Inter-American Commission on Human Rights, that looked at the issue of enforced disappearances through the various rights that are violated by the practice: the right to life, the right not to be submitted to torture, the right not to be submitted to arbitrary detention in particular. So you have a number of decisions that have been taken in the 1980s, especially by those bodies, and that really looked more closely to on enforced disappearances. And then slowly from there, we moved to an autonomous approach of enforced disappearances with the creation of the working group in 1980, with the adoption more than 10 years after of the declaration, the United Nations Declaration on Enforced Disappearances, 1994, the Inter-American Convention on Enforced Disappearances, which was the first treaty adopted on enforced disappearance, and finally, in 2006, the adoption by the General Assembly of the Convention for the Protection of All Persons Against Enforced Disappearances in the United Nations. Now, what are the key provisions? I'm not going to focus on such or such provision. I'll be ready again to answer to your questions. I just want to underline the different parts of the convention. If you look at the training manual, you will see that you have first a part with substantive provisions in the convention, and you start with Article 1 with the right not to be submitted to an enforced disappearances. So the convention sets out a new right, which is a right not to be submitted to enforced disappearances. Then you have those two articles on the definition, Article 2 and 3, that I quoted in the beginning. The next part of the convention relates to criminalization. It means that enforced disappearance is not only a violation of human rights, it's also a serious crime in international law. And there is a duty and obligation under the convention for the states parties to criminalize in their domestic order the crime of enforced disappearance as an autonomous crime. So not just as, approaching crime like abduction, for instance, but with a specific crime of enforced disappearance. Then you have a part which is dedicated to the search of disappeared persons, the obligations of states to search, to activate mechanisms to look for the disappeared persons, localize the disappeared persons with investigations that must be launched whenever there is, a reason to think that someone has been submitted to enforced disappearance. The next part is about the prevention of enforced disappearances, and this is please could you come back on the previous slide? The prevention of enforced disappearance is a central part, and it's in fact a very useful part, I would say, even for states that have never known enforced disappearance in their history, because it's the guarantee somehow that enforced disappearances will never occur in their future history. So this is really an encouragement for all states to ratify wherever they feel concerned today with enforced disappearances. And then the next part is about the rights of victims. Of course, central victims have been at the center of the efforts to fight enforced disappearances, and they have the right to truth, they have the right to justice, and they have the right to reparation. And Article 24 recalls those rights and spells out those rights in more details. And finally, Article 25 is about the abduction of children and the enforced disappearance of children, or children being abducted or being subtracted to their parents and their identity falsified through legal adoptions, in particular in the context of enforced disappearances. Then the next slide, you have procedural provisions, the provision of a new committee of 10 independent experts. This is the committee I'm a member of. And then the functions of the committee, which are basically looking at states report, Article 29, looking at urgent actions, central part of the action of the committee. I'm sure Alban will speak about it later. Individual complaints, which is the quasi-jurisdictional function of the committee. The states complaints that allow states to complain against another state under the convention. The inquiries, including the inquiries in the countries that can be done by the committee with the consent of the state. And finally, the possibility in cases where there is a practice of enforced disappearance that is amounting to a crime against humanity, for the committee to refer the situation to the General Assembly. Now, last point, and I will go fast. I will spare you the relation with the working group. I'm sure Angana will speak about this. So this is the next slide, and you can also, of course, I will send my presentation, and I share my presentation with all the participants so they can look at in more details to the slides. I will go to the next directly to speak about the convention's relevance to Asia. I just want to underline about this that only 8 Asian and Pacific states, I'm using the UN categorization, right? The regional group. Only 8 states of Asia and Pacific states have ratified the convention out of the group of 54. So this is a very low percentage of states. This is the lower percentage of states throughout all the regions of the United Nations, right? So you have Fiji, Iraq, Japan, Kazakhstan, Mongolia, Oman, Samoa, and Sri Lanka. Others have signed the convention, but have failed to ratify the convention, which is really regrettable because they could have done this further step to do the ratification. India, Indonesia, Laos, Lebanon, Maldives, Palau, Thailand, and Vanuatu. If you look at the working group report, you can see that there are 28 states that are listed. So meaning that there are 28 states that have on which there is at least one case of enforced disappearance in the region. And then if you look at the working group report, again, you can see that there at the end of the working group, there are graphs which are really instructive. I gave you some examples of those graphs, but there are graphs that are showing the number of cases of enforced disappearances by country and by year, according to the cases transmitted by the working group between 1980 and 2021. And those graphs are only looking at cases for which there are more than 100 cases transmitted. And among those states for which more than 100 cases have been transmitted, you can see that there are 7 Asian states that are represented: the DPRK, Indonesia, Iraq, Pakistan, China, Nepal, Philippines, and the Sri Lanka. Okay, so you can see that just from the taking from out of these figures, you can see the relevance of the convention for Asia, not only because there is a phenomenon of enforced disappearances in the region, but also because this is very important for the region to ratify the convention to better prevent enforced disappearances in the future. So the next slides, I will not go through the next slides, but I will transmit it to you. I've just copied and pasted basically the graphs of the working group for these states, and you can go and see. And you will see again that there are for some states like the DPRK, it's like some kind of continuous practice, but for other states, this is more situated in a particular period of time. If you look at the next, for instance, which I think is Iraq, you can see that there are peaks, ups and downs depending on the situations. And here again, you can see the link between the situation in the country at the particular time of history and the practice of enforced disappearances. So this is full of conclusions that you can draw from it. Thank you very much for your attention, and I'm glad to respond to your questions if you have any. And thank you again for the invitation.
Thank you very much, Olivier de Froville, for this excellent presentation. It was really enlightening. I will now give the floor to Ms. Ankana Nipalachit, member of the Working Group on Enforced or Involuntary Disappearances. Thank you very much.
Thank you very much, Arnold, and hello, everyone. I'm very truly honored to join this discussion on the global and regional challenges of enforced disappearance on behalf of the UN Working Group on Enforced or Involuntary Disappearances. As Olivia mentioned earlier about the situation in Chile and Argentina during 1973 to 1980s, in 1980, the former UN Commission on Human Rights unanimously created the mandate of the Working Group on Enforced or Involuntary Disappearances in response to the international outcry that this phenomenon has generated across Latin America and beyond. At that time, Representative gathering in Geneva raised this grave concern over the fate and whereabouts of thousands of names of individuals in different parts of the world, far apart, including Afghanistan, Argentina, Chile, Ethiopia, Nicaragua, or Uganda. This emergence of enforced disappearance was not limited to a specific geographic region. It was as a global problem requiring urgent action from the time forward. The work of working group reminded despot and authoritarian rulers that they were no longer able to shield responsibility for their detention, torture, and killing of people by simply refusing to acknowledge a deprivation of liberty or admit any responsibility. Thanks to effective campaigning by families and civil society, in 1992, the General Assembly adopted the Declaration for the Protection of All Persons from Enforced Disappearance, which paved the way for the adoption of the International Convention in 2006 and its entry into force in 2010. In the spirit of complementarity with the UN Committee on Enforced Disappearances, the working group fulfills its mandate by providing expert assessment of the implementation of the 1992 Declaration. It outlines international obligation to stop and prevent enforced disappearances, to protect the rights to truth of families, to punish the perpetrators, and to ensure the rights to an effective remedy. The Declaration defines enforced disappearances as an offense to human dignity and a grave of flagrant violation of human rights, which places victims outside of the protection of the law and inflicts severe suffering on them and their families. Those circumstances whatever can be invoked to justify enforced disappearances, whether a state of armed conflict or any other public emergency. Importantly, the Declaration defines enforced disappearances as a continuous crime as long as the fate and whereabouts remain unclarified. This allowed the working group to consider allegations relating to enforced disappearance irrespective of time they occurred. As a first UN thematic mechanism with the global mandate, the working group considered almost 60,000 individual cases to this day, including 5,362 women, transmitting information to governments and acting as a humanitarian channel between governments and the families of the disappeared in all regions of the world. Over time, the working group clarified the fate and whereabouts of close to 13,000 disappeared persons. With respect to Asia, the working group reviewed 36,397 cases, including 3,057 women. We are concerned about the cases of enforced disappearance in the Asia-Pacific region, as illustrated in our annual reports. However, those we receive are only the tip of the iceberg. Allow me to draw attention to the underreporting of cases of enforced disappearance, which continues to occur in the present time, including in this region. There are various reasons of this problem, including lack of awareness, impunity, weak administration of justice, or silencing of civil society, to list a few. We are particularly concerned about the instances of pressure, threat, or intimidation on the families or on the organizations working on their behalf, not to file or to drop their complaints related to enforced disappearances. The work of civil society organizations in the regions is particularly important to raise awareness about the existence of this horrendous practice and call for the right to truth of families as well as the accountability of perpetrators. Attempt of state to undermine or hamper the work of these civil society organizations should not be tolerated. Since its establishment, the working group conducted official visits and engaged with numerous stakeholders from the region, including visits over the last several years to Sri Lanka in 2015, Pakistan in 2012, Timor-Leste in 2011, and Nepal in 2004. Which produced country visit and follow-up reports. The working group has also sent visit requests and reminder to a number of countries in the Asia-Pacific region, notably to Afghanistan, Bangladesh, Bahrain, China, Democratic People, Republic of Korea, Iran, Iraq, India, Indonesia, Pakistan, Philippines, Laos, PDR, Nepal, Syria, Thailand, and Uzbekistan. A number of countries in the region also cooperate actively with the working group in relation to individual cases and others' communications, while others, unfortunately, much less collaborative. We are grateful to those countries in the region, notably Japan and Republic of Korea, which are supporting the working group, including with voluntary contributions, and hope that we can count on their sustained support. On 18 December 2022, the 1992 Declaration will return 30. For this occasion, the working group will conduct a study focusing on the contribution of the Declaration to the progressive development of the international law of enforced disappearance into domestic law and jurisprudence, the obstacle encountered and good practices and lessons learned. We wish to thank our stakeholders in the region who provide submissions for the study, including Qatar, Iraq, and Uzbekistan, as well as several civil society organizations and academic institutions. During its 125th session in September 2021, the working group decided to issue a thematic study on the issue of new technologies and enforced disappearances. The aim of the study is to assess how new technologies are used against relatives of the disappeared persons and their representatives, how they can be used to facilitate the search for the disappeared, and how they can facilitate the collection of criminal evidence amidst a climate of secrecy and challenging to identify and punish the perpetrators. A call for input will be issued soon to all stakeholders to inform this report. We hope that we can count on numerous input from the region. Also last year, the working group presented its annual report to the 48th session of the UN Human Rights Council, which including a thematic section regarding enforced disappearance in the context of transnational transfer. The report shed light to the issue of transnational transfers that led to enforced disappearances after states participated, supported, or acquiesced in their commission, often under the guise of counterterrorism. We note that in most of these cases, the allegations presented could contravene the standard laid out in the 1992 Declaration. Oftentimes, persons are abducted or forcibly disappeared as the point of detention as part of covert extratory operations by state or otherwise, also known as extraordinary renditions. The circumstance in which working group has documented most of these cases also point to violations of the non-reformal obligations of the host state. Unfortunately, a number of states in the region engaged in bilateral agreement to allow for the return of migrants and refugees in need of protection. Let me also point out that a few years ago, the working group began documenting cases tantamount to enforced disappearances when alleged perpetrators is the non-state actors, exercising effective command and control outside the authority of the state. It is in that spirit that the working group decided to transmit cases to non-state actors through its humanitarian procedure when it received the informed consent of families. It is important to clarify that whereas non-state actors and de facto authorities do have human rights obligations, the working group's engagement does not imply any form of recognition or opinion concerning the legal status of these actors. This is an important development, which is particularly significant for families who do not have access to remedies in their countries. As I conclude, please let me emphasize how important it is for states to ratify or accede the International Convention. The working group has repeatedly reaffirmed the imperative to fight impunity and has urged states to put in place an effective normative framework on enforced disappearances in order to meet its due diligence obligations. Although progress has been remarkably slow and unnerving in the region over the last decade, the working group will continue to fulfill its mandate and serve victims and their families in the pursuit of their rights to truth, the end to their suffering, and the delivering of justice. I thank you very much.
Thank you very much. Thank you for this excellent presentation. We will now hear from the experience from civil society from Mexico, with a focus on how ratification and most of all the use of the instruments provided by the convention has been really beneficial for them. The first video we will listen to will be from Mrs. Grace Fernandez from the Colectivo Búscame. She's a member of the Movimiento por Nuestros Desaparecidos en México. Noki, if you don't mind starting the video. Thank you very much.
Hola, buenos días a todos. Gracias a Naciones Unidas y al Comité contra Desaparición Forzada, pero sobre todo a ustedes por la oportunidad de hablar sobre la experiencia de las víctimas en México. Mi nombre es Grace Fernández, soy hermana de Dan Fernández, quien fue desaparecido en el año 2008 en el norte de México por agentes militares que trabajaban también para un grupo criminal llamado Los Zetas. Desde el inicio de esta tragedia, que digamos recientemente aqueja mi país, si bien no es algo nuevo, porque ya habían sucedido en el periodo de los años 60, 70 y 80, pero en un contexto de persecución política. A partir del año 2006 nuevamente vuelven a aparecer las desapariciones como un delito recurrente, pero agravado por la gran cantidad de personas desaparecidas y la complicidad de las autoridades con los grupos criminales que principalmente se llevaban a las personas, pero que lo hacían con la participación y aquiescencia de las fuerzas del Estado. Las víctimas hemos tenido un gran aliado desde entonces que ha sido permanente y constante, como lo es Naciones Unidas y sus diversos mecanismos. Eso quiere decir que desde el principio, tanto Grupo de Trabajo contra Desaparición Forzada como el comité desde su creación han estado al pendiente de lo que sucede sobre las desapariciones en México. Si bien mi país firmó la convención en el año 2009, fue sino hasta apenas el año 2020 que ratificó la competencia ratificó el artículo 30 para que el comité pudiera recibir las comunicaciones individuales. Sin embargo, mucho antes de esta ratificación, el comité ya venía solicitando al Estado mexicano información sobre qué estaban haciendo para buscar a las personas y para atender a las víctimas y procurarnos justicia a nosotros como familiares. Estas recomendaciones están basadas en la información que el Estado mexicano tuvo que proporcionar en 3 ocasiones al comité y que fue secundada o que de forma alternativa las organizaciones de sociedad civil y las víctimas también informamos al comité justamente para hacer contrapeso o tratar de poner un enfoque más objetivo de la realidad de los avances en la búsqueda y en la investigación de lo ocurrido a nuestros familiares. Estas recomendaciones lo que hicieron fue convertirse en nuestra agenda de trabajo, justamente porque los expertos decían lo que hacía falta que el Estado hiciera para poder atender. Le decía, tienes que tener una ley que tipifique el delito de desaparición, tanto forzada como la desaparición cometida por particulares. Tienes que tener un registro de las personas desaparecidas, pero en el contexto de cómo se estaba dando en México el fenómeno y las consecuencias de este delito, parte de las recomendaciones se empezaron a hacer sobre los temas forenses respecto a la necesidad de tener un registro nacional forense con los datos sobre las personas fallecidas y que no tenían identidad y que era necesario tener conocimiento más específico que nos pudiera llevar a su identificación. Estas recomendaciones fueron tomadas por las víctimas, los colectivos que como nos agrupamos para poder presionar al Estado mexicano a construir todas las políticas públicas para darnos una atención inmediata a los nuevos casos, pero también para hacer las investigaciones y las búsquedas efectivas de quienes ya teníamos unos años esperando una respuesta. Para nosotros era tan importante que el comité pudiera venir a constatar, porque no es lo mismo lo que un Estado pueda informar en 200 cuartillas o en el número limitado de caracteres que solicita el comité. Y otra cosa muy diferente es el ir al lugar y escuchar a las víctimas, pero también escuchar a las autoridades. Fue así que por más de 3 años las familias estuvimos haciendo campañas y presión política y mediática para que el comité pudiera ser invitado a venir al Estado y finalmente lo logramos el pasado noviembre de 2021. Estuvieron 10 días en nuestro país Visitaron 15 estados de la República, de los 32 que son. Sin embargo, se reunieron con víctimas de todos los estados. Lograron movilizarnos hacia las ciudades cercanas para poderles dar información sobre lo que hemos visto, documentado, vivido, sufrido y padecido para buscar a nuestros familiares. El comité no solamente tuvo la apertura de escucharnos, sino también la voluntad de acompañarnos a los trabajos forenses que hacen las propias víctimas para buscar a los que están lamentablemente sin vida y que fueron enterrados clandestinamente en lugares que no están destinados para ello y que tenían la intención de volver a desaparecer la evidencia de que esa persona falleció. El comité tuvo la oportunidad de ir a lo que llamamos los campos de exterminio y ver el trabajo de las familias y ver la misma preocupación que nosotros tenemos. Entonces, las recomendaciones que salió de la visita del comité, de escuchar a las víctimas, pero escuchar la versión de las autoridades y ver que estas son completamente opuestas porque sabemos las autoridades quieren engrandecer los pequeños esfuerzos y las familias queremos maximizarlos, ¿no? Tratar de estirar la voluntad política para que algún día tengamos la respuesta de qué fue lo que pasó con nuestros familiares y poder tener justicia hacia quienes cometieron este delito. Por un lado, el que se puedan recibir las comunicaciones individuales hace una complementariedad de la visita, porque es la información específica de los casos en donde van a poder ver de forma reiterada cuáles son los errores principales o cuáles son las carencias que tiene cada uno de los estados en atender e investigar y buscar a los desaparecidos. Pero también tiene esta parte de lo que desde la perspectiva de las víctimas que somos, quienes hemos estado dando seguimiento a la investigación y hacemos labores de búsqueda y padecemos estas carencias, es información que le permite al comité poder dar mejores y más amplias recomendaciones. Es por esto que las familias, como una de nuestras principales estrategias hacia cómo se debe de atender el fenómeno de las desapariciones, hemos apostado por apoyar no solamente la ratificación de la convención para recibir comunicaciones individuales, sino la importancia de la visita y sobre todo el cómo se retomen estas recomendaciones, porque son una herramienta más para nosotros en la exigencia de la búsqueda de verdad y justicia para nuestros familiares. Espero que estas jornadas sean de éxito para ustedes, que puedan tener muchas ideas que les ayuden a poder generar estas dinámicas y políticas públicas tan necesarias para la exigencia de verdad y justicia. Les mando un abrazo a todos. Gracias.
Thank you very much. We will now listen to our last presentation of the day, which is also a video message from Mr. Juan Carlos Gutierrez, Director of IDEAS, also a CSO from Mexico, who has been very active in promoting the work of the committee. So, Nock, if you wouldn't mind starting the video. Thank you very much.
Un saludo, mi nombre es Juan Carlos Gutiérrez, desde la Ciudad de México. Soy el director de la Organización de Derechos Humanos IDEAS, Litigio Estratégico. Nuestra misión es acompañar a las víctimas de violaciones graves a los derechos humanos, documentar sus casos y litigarlos a nivel nacional e internacional. En este sentido, IDEAS ha sido pionera en el uso de los instrumentos internacionales de Naciones Unidas y en particular de los órganos de tratados Me refiero al Comité de Derechos Humanos en virtud del pacto y también al uso del Comité contra las Desapariciones Forzadas de Personas. Estamos hoy conversando con ustedes y allí en el foro donde están reunidos quieren escuchar buenas prácticas sobre lo que hemos hecho en México y en otros países para implementar la Convención contra las Desapariciones Forzadas de Personas. Podríamos decir que los principales beneficios de la ratificación han sido abrir una puerta para que las víctimas puedan acudir al órgano de Naciones Unidas, toda vez que en nuestra región, en la Organización de Estados Americanos, el litigio ante la Comisión Interamericana de Derechos Humanos y la Corte es excesivamente largo. El sistema internacional de Naciones Unidas y la ratificación de la Convención nos han permitido, por un lado, tener mucha más agilidad en cuanto a la respuesta que el órgano del comité tiene frente a los casos, en concreto, las acciones urgentes. Y adicionalmente, hemos tenido también la posibilidad de recibir recomendaciones por parte de los expertos del comité que han precisado a México en su evaluación individual de país qué acciones tiene que hacer para combatir la desaparición forzada de personas. Nos parece que eso ha sido relevante para construir una agenda que nos ha permitido desarrollar la Ley General en materia de desaparición forzada de personas, que es una ley muy avanzada en México y que reconoce los estándares de la Convención Internacional. Además, las recomendaciones del comité han servido para que diseñemos una política pública, en concreto para avanzar en la identificación forense de las más de 50,000 personas que están desaparecidas en México y que aún no han sido identificadas. En este contexto, donde hay más de 100,000 personas desaparecidas, es importante entonces señalar que el comité de desaparición ha sido crucial en el trabajo que ha realizado en la materia. Adicionalmente, nosotros queremos mencionar que como abogados y abogadas litigantes hemos utilizado de manera muy activa el artículo 30 de la Convención que habla de las acciones urgentes. Una acción urgente que ha permitido salvar vidas de personas que se encuentran posiblemente desaparecidas de manera forzada, pero también una acción urgente que ha permitido varias cosas. Ha permitido garantizar la protección de restos óseos que se han encontrado en fosas clandestinas. También ha permitido que se proteja a las y los defensores que denuncian las desapariciones o que acompañamos casos, y en virtud de la acción urgente, el Comité de Desaparición ha solicitado al Estado mexicano que se proteja a víctimas y colectivos para que podamos continuar haciendo el trabajo de búsqueda de las personas desaparecidas. Y también hemos logrado que el comité se pronuncie sobre la investigación para encontrar a la persona desaparecida. Y en ese punto quisiéramos mencionar dos cosas. El primero de ellos es que nosotros solicitamos a un fiscal en un estado que es Veracruz que buscara a un joven desaparecido. El joven Víctor fue víctima de desaparición forzada por parte de grupos policiales en el estado de Veracruz y el Ministerio Público, el fiscal, dijo que no era competente para conocer de las acciones urgentes de Naciones Unidas. En ese sentido, nosotros presentamos un amparo, que es un recurso judicial, para pedirle que un juez le mencionara cuáles son las obligaciones que tiene una autoridad al firmar un tratado internacional como es la Convención contra la Desaparición Forzada. Inicialmente, la jueza negó que tuviese obligatoriedad la Convención, pero posteriormente logramos ir a la Corte Suprema de Justicia después de un litigio largo y la Corte decidió cosas muy importantes. Primero de ellos, decidió que México está obligado a cumplir los tratados de buena fe en virtud de la Convención de Viena, del derecho de los tratados 2, que la buena fe implica acciones que permiten reconocer tanto la Convención en su conjunto como los mecanismos que existen para la protección, en este caso las acciones urgentes. Y dice la Corte, quitarle a la Convención de Naciones Unidas la obligación de cumplir con las acciones urgentes es quitarle su aplicación real, fáctica. Y entonces en ese sentido hemos logrado una decisión muy importante a nivel mundial que nos gustaría que ustedes la conozcan a efectos de analizarla en términos de que las personas desaparecidas que tienen una acción urgente de búsqueda ordenada por el Comité de Desaparición Forzada, pues son obligatorias para todas las autoridades mexicanas. Y por último, México aceptó la competencia para recibir comunicaciones individuales, que es el otro gran punto que tiene la Convención contra la Desaparición Forzada. El artículo 31 lo señala y entonces nosotros desde IDEAS hemos presentado el primer caso contra México en virtud de un joven desaparecido también en el estado de Veracruz. Esperamos que pronto el caso se decida, está hasta ahora en etapa de admisibilidad y estaremos comunicándoles acerca de lo que el fallo del Comité de Desaparición establezca. Queremos invitarlos a leer algunas de nuestras publicaciones y aquí hay una sobre la desaparición forzada ante el Sistema de Naciones Unidas y el trabajo que ha hecho IDEAS. La pueden encontrar en nuestra página de inglés, la versión en inglés, y allí ustedes la podrán descargar para que sea de su consulta. Muchas gracias y agradecemos su atención. Un abrazo desde México a todas las defensoras de derechos humanos y a los colectivos que buscan a las personas desaparecidas.
Thank you very much. We now conclude the part of panelists, in presentation by panelists of this webinar. And the floor will now be open for any questions you might have, comments or experience you would like to share. Before opening the floor, I just wanted to remind quickly the housekeeping rules. So please do not unmute yourself until you are given the floor, and don't forget to mute yourself after your intervention. To take the floor, please click on the raise hand button, and the list of speakers will be prepared on a first come, first served basis. And we would like to thank you, or we would like you if you could please state your name when you take the floor. Feel free as well to post your questions in the chat. Questions can be addressed to Mr. Olivier de Frouville, a member of the Committee on Enforced Disappearance, to Ms. Ankana Nipaljit, a member of the Working Group on Enforced or Involuntary Disappearance, and to Mrs. Alban Prophet, Secretary of the Committee on Enforced Disappearance. Thank you very much. Without further ado, I will give the floor to Mr. Hossein, who has informed us that he would like to share with us his experience. Thank you very much. Mr. Zaman Hossein, you have the floor. AKM Hossein, you have the floor.
He disappeared. He's not online.
Okay, sorry, he seems to be disconnected. Could I ask if anybody else would like to has a question or would like to share anything with the members of the committee, of the working group, and of the Secretariat present? It can be linked to any of the presentations made or any questions you might have on the convention, on the history of the convention, on the manual, on the situation in the region as well. Please also let us know if you would like to share a comment, for example. I do not see any raised hands at this point. Okay. If there's no questions, I may give the floor back to either Ankana or Olivier if you have additional comments that you would like to share with the audience. And if not, then I might give the floor to Alban Prophet. Already, it's a bit of a shame that we are not able to have a conversation. But please feel free to still raise your hand at any time if you have any comments or questions. But Alban, you have the floor.
Thank you very much, Arnaud, and thanks to all of you for your participation in today's webinar. Yes, as Arnaud said, please do not hesitate to intervene if you have questions, comments, and in the future, do not hesitate to be in touch with the Secretariat of the committee. The Secretariat is a team of UN staff of OHCHR that is in charge of coordinating the work of the committee and to give a follow-up to all the activities that are carried out by the committee in all the states that have ratified the convention. I'm in charge of the closing remarks of this activity of the webinar for today. And really what I want to highlight is that as we have seen throughout the presentations that we have heard, the fight against enforced disappearance, the prevention, the eradication of enforced disappearance cannot be postponed, cannot be put on hold. It's something that is a reality today in many countries in all regions of the world. I've been working in many countries in all regions of the world, and in all parts have been the witness of the horrific impact of enforced disappearances. And I'm every day more convinced of one thing. Every case of enforced disappearance is an unacceptable knot of horror and suffering that cannot be described. And humanity as a whole must fight against this unacceptable scourge. Yet, as we've seen, as Olivier recalled, as the member of the working group recalled, it's not solely an issue of the past, and it is still practiced all around. As was recalled in the interventions as well, the convention represents a milestone in the prevention and combat against enforced disappearance. It is the first universally legally binding human rights instrument that concerns enforced disappearances. What does this mean? It means that it has a binding character on all the states that ratify the convention. It's like a formal commitment, a formal declaration of the states to support victims, to support the fight against enforced disappearances, to take action together to fight against this crime. The convention is the result of decades of fact, of work, of discussions, and it reflects the values. It reflects some values that, of course, would seem impossible to oppose. And as has been highlighted, despite the universal value of the content of the convention, the level of ratification remains incredibly low. As of today, we only have 68 states parties to the convention. And of course, it is a step forward, but it remains absolutely insufficient in front of the values that are described, that are contained in the convention. Indeed, the convention protects rights and describes obligations that we would seem not to be able not to agree with. It seems so essential to prevent enforced disappearances, namely to protect life, to protect freedom, to protect the right to identity, the right to be with the ones you love, and the rights of those who love to know where you are and to be with you. Who would not agree also that it is essential to combat impunity, namely to ensure that those who are responsible for the disappearance of someone are punished and that the victims have access to truth, justice, and reparation. And also, who would not agree that it is essential to combat impunity, to contribute to the non-repetition of this heinous crime in the future? Indeed, to ratify the convention, to achieve the universality of the convention, these goals should become fully operational. Through this universality, these goals could become fully operational. And enforced disappearances could indeed, at some point, hopefully become a crime of the past. Towards the same, each new ratification is a step forward. So I take benefit of having the floor here to highlight the importance that all states ratify the convention. We all know that to prevent and eradicate enforced disappearances is not an easy task. And the committee also knows it. Actually, in all states parties, there are points of the legislation and of the practice that can be improved. And precisely to ratify the conventions is a unique opportunity to improve both the practice and the legal framework, institutional framework. The committee is indeed here to support states, to support civil society organizations, to support victims, to take steps in this direction. It is only through action that things can change. And the exchange of information and experiences on the challenges that are faced and on the best practices is essential in that regard. This is done throughout the different procedures of the committee. Olivier de Fouville mentioned state reporting to the committee, through which the committee will review the situation of the states with regard to enforced disappearance on a global perspective, from a global perspective. Mr. Gutierrez and Ms. Grace Fernandez from Mexico mentioned the urgent actions. These urgent actions, I just want to highlight, is that a very quick procedure through which the committee can request a state to take immediate action to search for and to locate disappeared persons. And this procedure applies to all states that have ratified the convention. As of today, the committee has registered 1,506 urgent actions. The last one was registered 4 days ago. As mentioned previously, with regard to the big amount of cases that the working group has registered, it's a tip of the iceberg. And here is a very tiny tip of the iceberg. But it's really important to be informed about the possibilities of this procedure, through which the cases are elevated at an international level and made visible to the community and the world at large. The process of individual complaints that Mr. Gutierrez referred to is a quasi-judicial procedure, and it's also focusing on individual cases, but through a longer process that has specific requests and rules that I'm not going to describe here, but that you can very well see in the manual that was referred throughout this presentation today. But what is important is that through this procedure, the committee takes a decision determining whether the state has violated the convention or not, and making recommendations to the state to repair the damages suffered by the victims and to prevent future similar violations in the future. To summarize, to be a state party to the convention is not only a formal step. It is an acceptance by states to declare their support for the eradication and prevention of enforced disappearances. It is also an opportunity for states to make a balance, frequent balance, and to analyze each legislation, its practice, and to take all actions necessary to make its national framework more efficient and effective to prevent and eradicate enforced disappearances. It is also recognition by states that they're ready to learn from experts and also from other states and from victims and from civil society organizations. It is also an acceptance by states that they are part of a community of practice and exchange of information. Last but not least, it is a recognition by states of their responsibility to attend the cries and needs of victims who on a daily basis suffer the absence of their loved one and without any possibility to know where he or she is. In other words, it's a commitment towards victims, towards other states, and towards humanity as a whole, to take all actions that are at our hands to fight against this unacceptable scourge. So let's hope that more states ratify the conventions, and please do not hesitate to get in touch with the committee, with the Secretariat, with any of us who are here today to ask if you have doubts with regard to the convention, to the procedure of ratification, to the procedures of the committee, generally speaking. We are here to help. Thanks a lot to OACHR Regional Office in Bangkok for organizing this activity, and thanks to all the speakers for their interventions. Thanks also to each and all of you for your participation in today's webinar. Once more, I repeat, the eradication and prevention of enforced disappearances cannot be put off. We really have to fight and join forces against this scourge. Thank you very much.
Thank you very much, Alban. Just one last opportunity for those who would like to take the floor to ask any questions or share experience. And if not, then I would like to thank you. Thank you very much, Ankana, Olivier, Alban, for your time, for your excellent presentations and key messages. So thank you very much once again to all of you for being here. Thank you as well for Japan and Cynthia, representative of the regional office of OHCHR in Southeast Asia, for opening the meeting. And of course to Grace and Juan Carlos Gutierrez, who shared the experience from the Mexico perspective. Just before closing, I might just mention that the Committee on Enforced Disappearance is convening a day of general discussion in September on enforced disappearance in the context of migration, and that written submissions can be submitted until the 20th of June 2022. So thank you very much for your participation. Please go ahead, Alban, sorry.
Yeah, no, I just wanted to say that I will copy in the chat the email address of said Secretariat in case you have any questions or concern or consultation. So please free to send any consultation you may have. Thank you.
Thank you very much. And have a great afternoon or a good day for those based in Geneva. Thank you very much.
Thank you very much.
Thank you very much. Thank you very much, Arno, Olivia. Bye-bye.
Bye.
Thank you very much.
Thank you.
Thank you.